A patrol car's lights flare in your rearview mirror, red and blue washing over the inside of your vehicle. You pull to the side, heart rate ticking up just a little. The officer approaches your window, calm but alert, and after the usual greetings, comes a simple question that sounds harmless on the surface. Do you have anything in the vehicle I should know about? Or maybe they're more direct. Do you have any weapons in the car? What you say next, and just as important, how you say it, can quietly decide whether this stop ends in a warning and a drive home, or spirals into handcuffs, paperwork, and a long night you never expected. The unsettling reality is that most legally armed citizens mishandle this moment, not because they're reckless or dishonest, but because they think talking equals cooperation. And that misunderstanding ruins lives far more often than people realize. Picture this from the start. You're not a criminal. You're not hiding anything. You might even pride yourself on following the law to the letter. You vote, you work, you pay your taxes. Maybe you just left a ranged session, or you carry for personal protection because you've thought seriously about your safety. None of that prepares you for the psychological pressure of a roadside conversation with an armed authority figure asking open-ended questions. In that split second, your mind races. You don't want to seem evasive. You don't want to look suspicious. You also don't want to say something wrong. So you do what feels natural. You explain. You justify. You volunteer details to show you're a good person. That instinct, as human as it is where things often go off the rails. Imagine a driver named Daniel. He's heading home on a quiet evening when an officer stops him for a minor traffic issue. The interaction starts politely. License and registration are exchanged. Then comes the question, any weapons in the vehicle? Daniel decides honesty is the best policy. He nods and says he has a pistol secured in the console. He mentions he has a carry permit. He clarifies that the firearm isn't chambered. He adds that he was just at the range and everything is legal. From Daniel's point of view, he's done everything right. From a legal perspective, he's just stepped into a minefield he didn't know was there. Each extra sentence creates another angle for misunderstanding. Maybe the officer hears not chambered and assumes unloaded, while state law defines loaded differently. Maybe Daniel's permit expired recently and he forgot to renew it. Maybe the officer writes in the report that Daniel appeared nervous while discussing the gun. None of this requires bad intentions. It only requires human error. Defense attorneys see this pattern constantly. People talk themselves into charges without ever realizing it, not because they committed some violent act, but because words spoken casually on the side of the road were later dissected under a microscope. A traffic stop is not a friendly chat. It's an investigative encounter, even when it feels relaxed. The Constitution doesn't take a break just because there's a firearm involved. The right to remain silent still exists. The right against self-incrimination still applies. Carrying legally does not cancel those protections, but rights only help if you know how to use them calmly and correctly. When an officer asks about weapons, they're not just making conversation, they're assessing risk. Courts have long allowed officers to take reasonable steps to ensure safety during encounters. That includes brief investigations when they suspect someone might be armed and dangerous. Notice how specific that standard is. Armed alone is not enough. Dangerous matters. The problem is that once you confirm you're armed, the officer's subjective interpretation of danger comes into play. Your tone, your movements, your words, even your nervousness can influence that perception. Across the country, laws vary. Some states require people who are carrying to notify law enforcement immediately. Other states impose no such duty at all. The surprising truth is that many gun owners couldn't tell you which category their own state falls into, so they default to oversharing. Assuming disclosure is always required in many places, it is not. Consider an incident involving a man named Marcus in a northeastern state that does not mandate disclosure. During a routine speeding stop, he answered yes when asked about weapons and mentioned a handgun on his person. The officer's demeanor shifted instantly. Orders were barked. Backup was called. During the tense removal of the firearm, the officer claimed Marcus made a sudden movement. The situation escalated rapidly. No illegal items were found. Marcus wasn't charged with a gun crime, but he walked away shaken, humiliated, and thousands of dollars poorer after hiring legal counsel to clean up the aftermath. Nothing about that night required him to volunteer the information he did, yet that single decision changed the entire encounter. There's a way to navigate these moments that prioritizes safety, respect, and your legal well-being all at once. It hinges on a short, simple response that feels almost too plain to be powerful. 5 ordinary words that establish a boundary without hostility, words that courts recognize, words that prevent you from accidentally incriminating yourself while keeping the interaction professional. When asked a question you are not legally required to answer, especially one that could lead to further probing, the response is calm and direct. I don't answer questions. That's it. No explanation, no sarcasm, no raised voice. Just a neutral statement delivered the same way you might decline to comment in any other setting. Many people worry this sounds rude or confrontational. In reality, it's neither. You're not insulting the officer. You're not challenging authority. You're simply choosing not to provide statements. Courts have consistently upheld this right. Exercising it does not equal guilt. It equals caution. There's another crucial benefit. Silence cannot contradict itself. Once you start explaining, every detail becomes something that can be compared against other evidence or recollections. Memory is imperfect, especially under stress. Reports are written later. Words get paraphrased. Silence avoids all of that. If an officer presses, you don't need to escalate. Keep your hands visible. Stay still. Maintain a respectful tone. If they say they're just trying to keep everyone safe, you can acknowledge that concern without opening the door to questioning. You might say you understand and repeat that you don't answer questions. Then you wait. Some officers will test boundaries verbally. They may ask if you're refusing to cooperate. That phrase is designed to make you second-guess yourself. Cooperation does not mean answering every question. Cooperation means following lawful orders, providing required identification, and not interfering. You can calmly state that you are cooperating and simply not answering questions. In many situations, that's the end of it. The officer completes the purpose of the stop and sends you on your way. The encounter remains uneventful because you didn't give it fuel. And states that do require notification. The approach adjusts, but the principle stays the same. You comply with the law by informing the officer in the minimal way required, then you stop talking. Typically, that means clearly stating that you have a valid permit and that you are currently carrying. You do not need to elaborate. You do not need to answer follow-up questions about why, how, or where unless ordered to do something specific for safety. For example, if asked where the firearm is located, you can state that you prefer not to answer questions but will follow instructions. This keeps the focus on actions rather than dialogue. Actions can be controlled. Words can be twisted. There was a case involving a driver named Steven in the Midwest who complied with notification requirements, but then went further. He answered questions about chambered rounds, carry methods, and personal defense philosophy. What he thought was harmless conversation was interpreted as aggressive mindset. The stop escalated unnecessarily. It didn't have to. The objective of a police encounter is not to prove you're a good person. It's to conclude the encounter without creating legal problems. You don't win points for over-explaining. You don't earn protection by chatting. You protect yourself by being calm, compliant, and concise. Search requests are another common pressure point. If asked for consent to search your vehicle, you are allowed to refuse politely. Saying you do not consent preserves your rights. If a search happens anyway, you don't resist physically. You simply make your lack of consent clear and let the legal system handle the rest later. Resistance only adds charges. Tone and body language matter just as much as vocabulary. Visible hands, slow movements, clear communication before reaching for documents. These behaviors signal safety without sacrificing rights. You can provide required documents while declining to answer questions. Those are separate legal issues. Officers may try different conversational strategies, friendly rapport, shared interests, subtle pressure, implications that talking will make things easier. Each of these is designed to elicit information. A consistent, calm refusal shuts them all down without hostility. The criminal justice system is built on statements. Innocent people are charged every day based on what they said, not what they did. Laws are complex. Definitions vary. Officers are human. Reports are subjective. Silence is the one strategy that removes ambiguity. Imagine a scenario where you casually admit a firearm is loaded, not realizing that a specific transport exception applies in your state, or an officer misquotes you in a report, turning a neutral fact into something that sounds reckless. These situations begin with words. They end in courtrooms. Remaining silent does not guarantee you will never be arrested. Probable cause can still exist. The difference is that you haven't handed over evidence wrapped in your own voice. That alone can be the difference between charges sticking or being dismissed. Respect and rights are not opposites. You can show courtesy without surrendering legal protections. You can care about officer safety while caring about your own future. Understanding that balance is what separates informed citizens from people who learn the hard way. When the question comes, remember the simplicity of the response: calm, neutral, minimal. In places where disclosure is required, comply and stop. In places where it is not, you are under no obligation to volunteer. This knowledge is not about being difficult. It's about being prepared. It's about recognizing that a traffic stop is not the place to educate, justify, or explain. It's a place to be steady, quiet, and legally aware. The worst time to learn this is after you've already spoken. The best time is before the lights ever flash behind you.